Good afternoon. Good afternoon. Good afternoon. Good afternoon. Good afternoon. I'll say you're welcome back. Good afternoon. I'd like to quickly give you the feedback on the court hearing that we just heard in my office this afternoon at lunch hour. One about, I think we had it around 1 o'clock, now 10 past 1, and we spent 30 minutes on the hearing. The reason why I want to give you feedback on it, I want to give you the analytical part of it in the legal processing. When you are putting in an application completely on a gen, we call it in a gen 3.2, which is outside the rules. We call it gen 3.2, outside the rules. To be able to make an application outside the rules in a situation that I want to explain to you, these are the things that you will need to be aware of. The Home Office doesn't care how much it costs the government to drag the case on a long term. They don't care how long it costs them. But I care about the cost. I care on the cost it will cost you. I feel for human rights. I feel for individual migrants that will waste money in the court of law when they haven't got a case for court to heard. In this particular matter, I have come out previously to talk about this case. Someone has asked me recently, thank you dear, thank you dear, thank you. Someone has asked me recently an update on that particular case that I mentioned last time. But they did not manage to tell me the case, the name of that case. But this time around, I want to give you the feedback on the case that we have heard on the Zoom hearing today from my office, possibly from the judge office, in our office as well. Remotely connected it with the court clerk. The Home Office wasn't there. The reason why the Home Office was not there, they are the only one that have an answer to the reason why they are not there. Thank you, dear. Thank you. But I will have to let you know they will not come because they know the damages they have done. And they know that by coming, it will mess them up if they attend today on the remote hearing. But having said that, we only had a second time CMR, which is what we call case management review. A second time CMR. We're not going to have the full hearing until later part in the year, but I won't give you the date. Until later part in the year. What I want you to go away with, especially those who may later on come into this kind of situation as a client, an applicant or an appellant, listen carefully. The Home Office, which is the Secretary of State for the Home Department, as we speak, as of today's date and as of today's time, check the time, 15:40 in the UK, 15:40, which is 20 minutes to 4 in the United Kingdom. The Home Office, as we speak today, the 2nd of September 2020, has not found it in their guidance, hasn't found it in their records, You've started again, hasn't found it in their record, has not found it elsewhere to allow couples where one of them has overstayed his or her status in the UK and the other one has British passport and none of them has a child that is below the age of 18. As we speak, the Home Office has not incorporated into their guidance, into their rules, into their law. So it's a huge argument. It's a huge argument. Now, if anyone come up to tell you that it is easy, they are deceiving you. I enjoy litigation, especially in immigration law. I enjoy advocacy. I enjoy it. To litigate is a part of the law. It's part of what we do as a lawyer, and we eat as a lawyer. But one thing I want clients to be aware of and to be careful with is when you are pushing an application that will not succeed and you are pushing it in the hands of lawyers, they will eat your money. Take it or you leave it. Lawyer will capitalize and eat it. Let me take you through the step. This particular case, I have mentioned it to you before. They got married, but the other person has run out of status, but the other one has UK passport. They are both young. They don't have child at the moment, and they're not ready. They're not ready to have kids at the moment. They do not want to have kids because of pushing it for immigration reason. They want to be ready financially, mentally, and physically before they can even go in at all to say that they want to become parents. But as in times of marriage, exchanging of documents is easy. Once both parties are 18 or above, they can easily sign documents to bound each other, 18 or above. But when kids is there, when you have a child inside that relationship, it becomes a different thing entirely. But inside the immigration rules, inside it, the Home Office, the Secretary of State has not incorporated any that we would call an opportunity for someone that hasn't got kids and is in relationship with a British passport holder. The Home Office has not put in any leeway, has not given it allowance inside this document as we speak. Now, if for any reason a client now wants to rely on that particular area, the lawyer that's going to handle the case has to be one of the finest. And this is where we come on. It has to be one of the finest. When we talk of finest, we're not looking for tick anymore. We are now looking for a way to think outside the box completely. Which means that statement of fact, which means that the witness statement prepared for the appellant, which is the client and his wife or our husband, whichever one is the later, must be able to show that there is going to be a breach to their family life if that application is completely refused. Not only that, there is something we call exceptional circumstances. The interpretation of exceptional circumstances is not under the law. It's not under the Home Office guidance. It's from the judge's precedents when you have to show case laws. Referring to case laws, you can pick it up from the Court of Appeal case law, you can pick it up from Supreme, you can pick it up from Upper Court. It doesn't matter. As long as those cases are relevant to the rule of law, to the point of law, and to the facts before the judge, you will now start talking. You will now start talking the real law. In this scenario, I don't want to make noise, that's why I'm really talking, In this scenario, insurmountable obstacles is what we're looking for. And it is what is taking us into court, CMR. That's what we're looking for. Insurmountable obstacles. As we speak now, the Home Office, I prepared my skeleton argument for the judge to have it in advance 2 months ago. I also prepared a skeleton argument for the Home Office to have it in advance 2 months ago. The same statement I gave to the judge is the statement I gave to the Home Office, and documentation to corroborate that evidence. The Home Office prepared their review and misrepresent the fact that they did not receive document from me. Now, in a civil matter like this, which is an administrative law, politely it is agreed that another CMR will have to take place. Another CMR will have to come up, which is the case management review, because the Home Office has misrepresented the fact that they did not receive from me further documentation to corroborate the insurmountable obstacles, which is not true. I won't say my colleagues are lying, but they have misrepresented the fact. They have misrepresented that fact. They did receive documentation which could have easily closed the case down and resolve it to the advantage of the client. But the reason why the Secretary of State did not want to concur is basically because the Secretary of State did not want to open the floodgate argument. The Secretary of State did not want to open an opportunity for other people to use that kind of argument, which means that if they were to have accepted the document as being received and changed their decision, I would have eat. I know more than 100 people, if I close my eyes, that are in that situation. No children, in relationship with a British person, they are old, they cannot have kids. But the Secretary of State then has discriminated against married life, has discriminated against couples in a way that is saying that unless a child under 18 is in that relationship, she's not going to accept it as one of those. So in that case, is the reason why the representatives of the Secretary of State misrepresent the fact by saying that they did not have the further documentation that I supplied. And that brought the judge to the second CMR today. Why it is acceptable that they are entitled, because they are the Secretary of State, so they have overall power. It doesn't go like that in the law. And it is the reason why they're not here today. Because if they were to have been present for the court CMR today, I personally, Tokunbo Olagbaye, I would have roasted this agent alive. I would have roasted the Home Office presenting officer alive on the Zoom hearing. Not in terms of putting her in the fire and eat her, but at least on a legal argument, I would have roasted him or her today. But because they know the repercussion of what is likely to take place, they did not come for the hearing today. They are not there. Which took judge to the second level of changing her position. The role of the judge changed immediately because the Home Office wasn't there. So the judge have to become, at the same time, advisorial, at the same time, inquisitorial. Understand? Adversarial and at the same time operating inquisitive, which means inquisitorial. In that two form, I'm the only one that will have to take the bullet from the adversarial, take the bullet from the inquisitorial, which is the same person, the judge sitting for the CMR today. Now, having said that, we didn't come to conclusion. We only came to conclusion for a substantive hearing date. A substantive hearing date means when we will hold the final hearing. So we didn't come to conclusion to adjudicate, to complete the case today. The case did not complete it today. We are going to have a completion of the date for the hearing. They have given us a date, but I'm not going to put it to the public arena for many reasons. But the hearing is going to take place later part in the year, which means that we are going for full hearing. Let me wait whether my friends will turn up to come and clear their mess on that day. Whether they turn up to clear their mess or they don't turn up to clear their mess, the judge has checked with me if that date I am going to be in the country. Even if I am out of the country on that date, I will fly back into the United Kingdom to make sure that I am the one that's going to do that case. That case, I am not giving it to anyone to do. And I will expect them to turn up on that day. But in the meantime, in favor of my client, I have supplied the reason why it will be unjust not to decide the case in his favor. I have supplied the reason why Article 8 will be breached if the case is not decided in his favor. And I have supplied evidence of what it will mean as insurmountable obstacles, meaning that it will be impossible to relocate into another country for so reasons. I have supplied all those evidence. What is now left to me on the day of hearing is to just question my client. I will question my client, which is the appellant. I will question all the witnesses he may bring that we have supplied documents on their behalf. The witnesses will be, they can be 10, they can be 20, it doesn't bother me. And that's the reason why the judge has asked for 3 hours case for the full hearing. So it's been slotted for 3 hours. Now we can go more than that, it doesn't matter, but it's going to be up to that because of all the witnesses that I am going to allow to come into the case, and we are going to question them. The reason why. Now let me tell you another point in this case. The Home Office is wasting public funds. The reason why I said the Home Office is wasting public funds is simple. That case could have easily been resolved without a need for us to escalate it for today's CMR second time or third time, and then for another full hearing. Is a waste of public funds. The reason being is that even though they are arguing that there is no kid, no child between the parties because he came to UK, he was a student, he has overstayed his status, they want to punish him. By the time we are going to go for that case, for the full hearing, appellant will only have 8 months. 8 months to go to spend 20 years in the UK under private life. So, had not be married relationship in his case, he will still go ahead and make a private life application and succeed. Had there not be family relationship in his case, he will still go ahead, make an application under private life, under paragraph 276 ADE, and he will still succeed in the end because he only has 8 months to be 20 years in the UK. So whether lawful or unlawful, it doesn't matter. As long as there is evidence, the Secretary of State accepted that there is evidence of his entry into the UK in so year, which is 19 years ago. So regardless of all odds and any argument, at the end of the day, full hearing. That is how we do it in law. You make your case clear and you back it up with the rule of law. But the Home Office knew that they would fail. That's why they didn't attend today. So that means that they waste the public funds by allowing a judge to sit. Whether Zoom or no Zoom, it's a time constraint and they have to pay that judge. My client has paid me, so there's no need for me to talk about any other thing. But I feel for that client. Before that client reached me, He has used several lawyers before he reached me as his last stop. And I look at it and I say, okay, now that you have come to me as your last stop, bus stop, leave it with me. Let me show my skills and let me show what I'm capable to do. So ladies and gentlemen, that is the feedback I like to give you on that matter that we talk about on Article 8, family life in the UK for someone or for a couple who haven't got kids in their relationship and they have spent their life together more than 2 years as husband and wife, and there is a marriage certificate, and one of them is a British citizen and the other one has run out of status. These are the likely arguments you are going to face. And if you don't have insurmountable obstacles or exceptional circumstances to corroborate, your case will fail. So get a good lawyer before you make that mistake. It's not an application anyone can do by themselves. God bless you. I'll have to go now. My name has not changed. Lawyer Tokunbo Olagbaye. You can reach me on 0208 309 8808. 0208 309 8808. Thank you. Thank you. Bye.